Hello, welcome to the Sounding Board. Today we're talking to Joe Magnas. So, Joe, tell us a little bit about your role at Protalix.
I'm in-house counsel at Protalix, handle everything legal, and that covers mostly contractual relationships and, more importantly, everything that revolves around the capital markets.
So, Joe, let's talk a little bit about dual listings and some of the challenges.
The way that advertised it and tried to attract companies to do a list is to bring up some of the advantages. And there are many advantages. First of all, you have the home court effect. You can increase the shareholders you get, can increase your trading volume. You have additional methods of capital raising. You have longer trading hours since you'll be trading on two different exchanges and different days. For example, the Tel Aviv Stock Exchange trades on Sunday because that's a regular workday here in Israel, although it does not trade on Friday. And of course, you also find yourself open to the local indexes, et cetera, which has the ability to increase the liquidity of the stock. And those are the primary advantages of dual listing. We realize some of those disadvantages is if those factors don't come true, if you're not increasing your trading volume substantially on the Tel Aviv Stock Exchange, if you aren't getting a lot of extra shareholders, well, then you've increased your workload without getting the advantages. An additional thing that really, in my opinion, was problematic is we were not able to reach out to the shareholders as well as we're able to through the US holders. You don't have a form of like a NOBO list where you'll see in the United States. The institutional investors are not required to file as many filings with the Tel Aviv Stock Exchange. So you're not necessarily going to find the shareholders when you need them. And when it comes to proxy season, that could be problematic. Of course, when the shareholder might not be very happy with you, they know how to find you, but you don't necessarily know how to find them. And we found that to be very problematic for us. It really hurt us in the shareholder outreach times around proxy seasons. One thing I should mention I thought was very interesting, in December 2022, the New York Stock Exchange and the Tel Aviv Stock Exchange signed a memorandum of understanding to promote a number of things, including dual listing between those two exchanges, which one would think would actually be helpful. What I thought was interesting, and people listening can interpret it as you will, one of the claims made in the press release announcing this memorandum is that the two exchanges would collaborate in a variety of other matters, not just the dual listing, which would include, amongst other things, the ESG policies. Here in Israel, the ESG policies are not as easy. Diversity in Israel is not the same as diversity in the United States. So finding the people for your board and for your management isn't as easy as it might be in the US. So I thought that was an interesting tidbit in the press release. One thing that I did find really interesting in terms of the dangers is the regulations that make it easy for a company to do a list in Israel. Their primary listing must be with what they call a qualified exchange, which there's about 10, 15 exchanges named. And, I won't list all of them, but of course, the primary ones for our purposes are the NASDAQ, the New York Stock Exchange, et cetera. If you're on those exchanges, you can take the lesser regulated approach to do a listing. I was reading an article about a company that I was not familiar with. They had done that. They were a foreign company, elected for whatever reason, I don't know what it is, to do a list here in Israel. The dual listing was not very successful. It did not bring them the extra trading volume that they needed. One of the reasons why they did it was because they were desperate for increased shareholder volumes. And I guess sometime after the dual listing, they were delisted in the US, which made them no longer qualified for the easier regulations on the Israeli exchanges. So they found themselves being subject to the regular listing obligations for a company listed on the Tel Aviv Stock Exchange, which meant, of course, they had to start translating their reports, et cetera. In their case, they just simply stopped doing it. And since they weren't located in Israel, The Tel Aviv Stock Exchange had a hard time seeking any enforcement actions against them and eventually just delisted them.
But
I
certainly
guess
not something, Joe, that one wants to emulate or repeat.
no, definitely not. It was very interesting that it's something I didn't even think about until I read that article was you're relying on the foreign listing to give you the exemption. And the moment you have a problem with that foreign listing, your Israeli listing is going to be problematic, maybe even impossible. Delisting on one equals delisting on others.
Well, you've given a great overview of some of the issues and some of the considerations. So thank you for spending a little time with us.
No, it's my pleasure.